Yeah, please, Your Lordship. Lordship, I beg to mention item 3.
Item 3.
Yes, Lordship, on behalf of P. Janta. Lordship, let the matter be clearly come out after 2 weeks, Lordship.
Lordship, I have no objections, provided that my interim is extended.
What is the matter?
It's regarding recovery of loan, but they are trying to recover the loan from my pension, my lord, which is not permissible under the law.
It is,
61 of the...
it is under an order of stay.
Yes, my lord.
Learned counsel, appearing on behalf of leading counsel P. Chanda for the respondents.
Applicant in IA, Lordship.
Yes, and in the IA, what is the respond number?
The sole respondent, my lord.
Sole respondent. Seeks an adjournment and prays for listing the matter after
2 weeks.
2 weeks. The petitioner counsel, so and so, sent here, submits that he has no objection, but prays that the interim order may be extended first. Allowing the said prayer as well, the interim order, white order dated so and so. It's always better to mention the date.
My lord.
White order dated so and so. We'll check from the records.
My lord, my lord.
Stands extended till the next day of date of listing.
Lordship, I may be allowed to move unlisted bail application, Lordship. It is only for issuance of notice, my lord. Deeply obliged.
May I please, Lordship, please allow me to move one unlisted item. I file one bail application on medical grounds. Are you back?
Yes, Your Lordship. I beg to mention item number 4.
For orders.
Yes, Your Lordship. Service are still awaiting.
No, Lordship, there is no contempt in this matter, Your Lordship. There is no contempt because we have already complied. The then incumbent had already complied. So what would be the new incumbent would do? So there is no contempt. Lordship, let the matter may be called and look into my affidavit. Everything has been complied.
Can you wait a little?
Lordship, if in that case, let this matter will come up next week. Since this matter has been taken up by me.
No, we can consider your prayer for adjournment. It's only for item number 4. I will consider your prayer for adjournment. But as Madam has said, let the matter come up. We'll look into it and then try to accommodate you if necessary. Otherwise, we'll fix it early next week. Motion. Any other mention?
May I please, Your Lordship? May I be pleased to mention item 8, Your Lordship. Lordship, here I am yet to get my the CD, Your Lordship, updated CD.
Criminal petition.
Yes. So if the matter can come up after some time again, sometime maybe given to me.
Learned counsel. Item 8.
Item 8.
Submits that the scanned or original you're called for.
Scan or original?
The case diary has the case diary which is necessary for adjudication of this criminal petition, has not yet been received, and prays for posting the matter after
After 3 weeks.
after two
2 weeks.
after 2 weeks, allowing the said prayer, list the matter after 2 weeks. Should I fix a date or not necessary?
It's up to the convenient.
We fix a date also. Today is 4, right? Let it be on 18/9. Fine? 18/9, ma'am. 18/9.
Much obliged to you.
For admission, item number 1.
Yes, ma'am. What is this? You put on the fan. Right.
May I please, Your Lordship?
Let me see the last order, right?
Your Lordship.
Just a minute. Okay, I've read the last order, 18/8.
Yes, Your Lordship. As per the direction of this court, I have filed the affidavit, Your Lordship. So if the affidavit can be called for, because I filed this morning only, Your Lordship.
Okay.
So if the affidavit can be called over, and meantime, Madam Mayor can proceed, and Your Lordship, meantime, my affidavit may be called for.
Yeah, I call for that.
Lordship, just a short time so that I can also file my counter affidavit. They are,
Have you received a copy of the affidavit?
this
Filed by
only
the-
now,
Okay,
only now I'm,
So in that case,
a short time may be given.
Mr.
Their prayer is that
Salary.
they are filing review, but that does not
Review,
the,
read petition.
preclude the contempt to be proceeded. Because
Your
there
Lordship,
is,
Your Lordship, what happened is that, so my humble prayer is that at least hear our submission as to why the salary has also been delayed, and we have a practical difficulty also, even in the days to come. So it's our duty to inform this court. So let the affidavit be called for.
and in the meantime, they can
Yes.
also file a counter. They
Yes,
said.
they can file and reply, no problem, Your Lordship, but at least hear our submission key as to why we could not able to pay on time and what
In that case,
practical
the-
difficulties we are
The
facing.
proceeding will, the pleadings should be completed in that case, right?
No, Your Lordship. Your Lordship, affidavit is, I filed this for you, so let it come, Your Lordship, and we can come. We can take after some time, Your Lordship.
After some time. Okay, let the affidavit be called, but you can file the reply. I will
Lordship.
pass the order after some time. After some time.
I have a matter in.
Okay, please do and you can please do that matter. Get the affidavit into this case.
For admission, item number 2.
Please, Lordship. Lordship, here I'm yet to file my affidavit in reply. Kindly allow me some more time to file my affidavit, Lordship.
I believe only 2 respondents, right?
Yes,
Respondent number 2 and the respondent number 2 has already filed a objection, right? You want to file a reply to that.
Lordship.
In the meantime, should I admit the matter? Should I admit the matter? It is at the stage of admission. So it can be posted for hearing. In the meantime, you
Lordship,
file your
Lordship,
reply, right?
Lordship.
Learned counsel, good name.
James Kohima.
Appearing for the petitioner, seek some time to file a reply to the written objection filed by the respondent number 2, an informant,
Yes.
/ informant. Learned public prosecutor and the learned counsel for respondent number 2 is also present, are also present. The petitioner would be at liberty to file his reply to the objection. In the meantime, the matter which is at the stage of admission stands admitted for hearing. Leaves the matter for hearing after
3 weeks.
after 3 weeks. After 3 weeks. You want a fixed date or let it be?
No, after 3 weeks.
In the,
Lordship,
in the meantime, you file the reply.
Lordship, there's an interim. If interim,
There's an
that's
interim order. The interim order granted by order dated so and so. Constitutional submission and state of order. By order dated 6/8/2024. Staying further proceedings in CR case number 11 of 2024. Right? Pending in the court of learned CJM Dimapur.
Dimapur.
Shall continue till the next date of listing.
Lordship.
For orders, item number 4.
Lordship, if you see the newly implemented person, it is
Let me see the cost tag.
the newly implemented person are the secretary, the chief engineer, and the engineer in chief, and the chief engineer National Highway. The direction is given only to the DC, Lordship.
Only to the DC.
Yes, only to the DC, and accordingly, I have filed the affidavit, Lordship. If your Lordship turn to, they have not even paginated here.
Just a minute. Huh? Yes. There were already 8 respondents already there, right? 8 respondents were already there. Am I right? And that newly implemented respondent number 9, Olan John and Deputy Commissioner.
No, Pauline John too, he had already filed his affidavit, Lordship.
Who was the newly implemented, madam?
Response number 10, 11, and 12, Lordship.
Okay, 10, 11, 12.
Yes. Direction has not been given to this officer, Lordship.
Lordship, however, this case has been related to a highway. So, the engineer in chief as well as the chief engineer of national highways are also answerable to this case. So, let this matter be come up.
Is it for compensation?
Yes, Lordship, if you see the direction of this court, it is only directed to the DC Dimapur and Chukmukadima to conduct the verification.
Okay, 8 were there, then you have implemented 9, and then 10, 11, 12. Though Madam says they may not be necessary. Only the direction was to the DC.
Direction. So, Your Lordship, may kindly look into my affidavit and whether there is a willful violation on the part of the contender. Because contempt is between the court and the contender, not with the petitioner. So,
That is true.
the direction, Your Lordship,
It's come up for orders today for any specific purpose or for, let me see.
notice is everything on.
It's the
The newly
service
implemented-
okay, newly
yes,
implemented 10, 11, 12.
Yes.
Is it completed? The service, let me check
Service
the
is
office
not
note.
completed, Lordship.
Return service reports are awaited. Notice issued, okay, 10, 11, 12. Steps have been taken, service report is awaited as per office note dated 1/9. 1/9. But let me see what you are trying to point out. You want me to see which page?
Lordship, there is no running page here in my
Okay,
petition also,
never
but
mind.
Lordship, may kindly turn to page 52 of the judgment.
52 of the judgment.
Yes, para 34. Has Your Lordship got it?
Para 34.
Yes. Considering the above, this court therefore disposes of the instant repetition with the following observation and direction. So, Lordship may come to direction number 2. Taking into account that this court is not in a position to decide how much and which land of each of the petitioner or any of the landowners have been affected, it would require a fact-finding inquiry. This court directs the petitioner to submit their claims, including their claims for destruction of the properties, along with their land documents and other documents for verification before the Deputy Commissioner Dimapur and or Deputy Commissioner Chumuketima, before whose jurisdiction their land falls within 45 days from the date of the instant order, taking into account that only 230 petitioners have filed the instant repetition and there may be other landowners who may have been affected. This court further directs the Deputy Commissioner Dimapur as well as the Deputy Commissioner Chumuketima to issue a notice in a news daily of wide circulation calling for any claims along with their documents for verification. The same should be done within 20 days from the date of the instant order. Their Lordship 3, on the basis of the claim as well as the documents so submitted, the Deputy Commissioner Dimapur and Deputy Commissioner Chumuketima and or any person to whom the Deputy Commissioner deemed fit to entrust but not below the rank of Additional Deputy Commissioner shall verify the said claims on the basis of the documents submitted within a period of 6 months from the date of the submission of the claims by the petitioner person interested. In filing the said claim, the petitioner as well as the landowners would be at liberty to also submit claims regarding their loss suffered on account of demolition of their properties. Then number 5, Lordship. It is made clear that if in the circumstances the petitioners and or the landowners are aggrieved by the fact-finding inquiry by the office of the Deputy Commissioner, the petitioners and or the landowner would be at liberty to initiate proceedings under the Code of Civil Procedure 1908. Lordship say, so already we have done the verification, we have brought out the report. If at all they are aggrieved, they should go to the civil court, but not by way of filing the contempt, Lordship. There is no willful violation on our part. Accordingly, I have held my affidavit, where most of the
just a minute,
petitioners,
para 4, again it says that upon verification, this verification was directed to be conducted
by the
according-
DC,
but
Dimapur
they
and
have,
Chumuketima.
Dimapur and
Yes.
they have already done the verification.
They have already done,
Now
yes.
we come to the direction in para 4 then.
Yes.
If they have been found to be so and so, respondent, then initiate proceeding for
Yes,
acquisition.
there
That
is
means-
nothing. As per our report, most of the petitioner are in excess occupation, Lordship. In excess occupation, so there is no provision for initiation or further acquisition, Lordship.
So according to this finding,
Yes.
prima facie, they have not suffered any loss.
No. Some too they have. So accordingly, we have assessed the property and we have forwarded to the government for payment, Lordship.
So this 6 months period is over.
Over, yes.
So you can take an extension actually, and that is always better. Always give the exceptions. Because sometimes there might be some genuine difficulties
Lordship,
also.
within this period, we have already done the verification.
Verified
And
their
they
claims
have filed
within 6 months. Okay.
Yes, so within that period, we have done.
So you have two limbs of your arguments at this stage. That means that since the verification has been completed within
Yes.
6 months,
Yes.
there is no contempt.
There is no
Secondly, the
contempt.
direction is only to the two deputy commissioners
Yes, to the
of the two districts.
yes,
so
and
the
if
other so many respondents are not necessary.
Not necessary. And if at all they are aggrieved, Lordship, they should approach the civil court because this court has given the liberty.
But any instruction or submission you want to make at this stage?
But Lordship, the contempt is between the court and the contempt. I've been submitting the submission long time back, but the court was gracious enough to always grant the time to them, Lordship. So this cannot be continued, Lordship, because it's when the contempt is pending, it amounts to mental harassment to the concerned contemnor, Lordship. They report everything, Your Lordship. Most of the petitioners, they are in access occupation. Their area is within the italics with their pata. Everything, Your Lordship, I've mentioned.
Write a short order. The as reflected in the order dated 30/11/2023, the petitioners, 226 petitioners have filed this have initiated the instant contempt proceeding, alleging disobedience with judgment and order dated 29/11/2022, passed by this court in WPC 185 of 19. Originally, 8 respondents were impleaded, and subsequently, respondent number 9 has also been impleaded, followed by impleadment of 3 more respondents, being respondent number 10, 11, and 12. Upon perusing the last order dated 12/8/2025 and the office note dated 1/9/25, I find that notices have been 9 has been served. 9 has been served.
Yes, Lordship.
It is. I find that notices have been issued upon newly impleted respondent number 10, 11, and 12, but service report is awaited.
If it is DC Chumo, Lordship, I will enter agreements on respondent number 9. But the previous incumbent, DC Chumo, has already filed his
Respondent
affidavit.
number 9, she has served copies, he said. Learned government advocate appearing for respondent number 1 to 8, right? 1 to 8.
No, Lordship, for 3, 4, 3, 4, 5, 3 to 9, Lordship.
3 to 8.
3 to,
3 to 8, submits that she will also represent respondent number 9.
yes.
Full stop. Drawing my attention to para 34 of the judgment, the learned government advocate submits that firstly, the direction was only to the two officials, namely Deputy Commissioner Dimapur, learned Deputy Commissioner Dimapur, and the learned Deputy Commissioner
Chumukindima.
Chupni. Full stop. It is further submitted that in terms of the direction of this court in para 34, both the deputy commissioners have already undertaken the exercise of verification of the claims of the petitioners with regard to any damage suffered by them pursuant to the public works by the nature of widening
Yes.
of the pertaining to the public works. pertaining to road construction. Let's write like that. In this context, the learned government advocate submits that apart from only 2 of the respondents being relevant in this proceeding, the order of this court has also been complied with, and therefore there should not be any, this proceeding should be dropped. So let me write that, it will be helpful. So what do we do now? I mean, what would be
Lordship,
your prayer?
it has to be closed, Your Lordship, because there is no willful
Your,
violation. It cannot be
your
continued,
senior
Lordship.
is appearing.
Lordship, in that case, let this matter be come up next week.
Let her give her a chance.
Lordship, you have to see, on the last occasion also he appeared, his senior appeared.
who's the-
I submitted the same submission.
Who's
Sir
leading?
Takamasa.
Oh, Sir Takamasa.
Because, Lordship, if at all they are aggrieved with the report of the verification, the liberty is given to them to approach the civil court.
But because since they have been implemented, rightly or wrongly, one step is also incomplete. One step is also pending. Plus, we have to give a chance to senior also to have his say. Even today he can come. But anyway, so let's fix it on Monday. But Monday this will not be complete.
Make it on Thursday.
Thursday. In the meantime, we can maybe have some report. So this will be helpful for. That's why I've recorded your submissions.
Otherwise, Your Lordship, I have been submitting the same submission since no time
It
back.
should be recorded.
And
It should be recorded and it can be heard. Then it can be fixed for
Otherwise,
hearing
Lordship-
and disposed of. So you tried on that day. List the matter. On next Thursday will be which date? 11/9. You just write one line before that. Await service report on 10, 11, 12. So we can have a report, and otherwise on 11th, if both sides agree, it can be heard and disposed of also. So you also discuss.
Otherwise, Your Lordship, there is no.
Brief your sir that if this was direction
is
was
no-
the direction was to do the verification within 6 months. If they have done that, then they may be right that they have done they have complied with the order.
Yeah, so there is no willful violation, so this should not be unnecessary kept pending, Your Lordship.
I understand.
For orders, item number 5.
It's also a contempt petition. Just a minute. I'm appearing for it.
Lordship, for respondent number 3 and 10. Lordship, sometime may be given to me, Lordship.
To file a reply affidavit.
Yes.
Lordship, if I may, Lordship. Lordship, this particular writ petition was disposed on 23rd of March 2023. On the basis of that, 8 months were granted. And then after that, he filed 2 IA application seeking for 6 months time, extension of time.
Extension.
It was granted, on the last occasion, that is on 25/11/2024, in the IA, this Honorable Court has cited no further extension of time. So after that, Your Lordship, on 17/7/2025, in the contempt petition, 1 was granted to file affidavit to respond number 3 and 10. And then again on 18/8/2025, that is
This is before me.
last Lordship.
This regarding it was directional for payment of pay scale,
Lordship. Time bound scale, Lordship.
time bound scale. So the last order reflects that the case of it was informed to the court. The case of the
Lordship.
petitioner is before the treasury. For
Yes,
pre-audit.
Lordship.
So maybe it's in process.
But Your Lordship, if it's before the treasury, then let them file an affidavit soon, Your Lordship. They-
I may be allowed to take instructions
She's
on
already
the
there.
status of the case, Lordship.
Learned government appearing for respondent number 3 and 10.
And 10.
What about the other respondents? They are not.
One is
And Nangami is appearing on behalf of contender number 1. However, he has his feet in the other court. So his appearance will
Okay,
also
no issues. He's okay. You are paying for the petitioner.
Lordship.
Appearing for respondent number 3 and 10. Seek some time to file an affidavit if necessary in the matter. regarding the present status of, up-to-date status of developments, comma, part of full stop. I find that it is reflected in the last order dated 18/8/2025 that it was informed to the court on behalf of respondent number 3 and 10 that the case of the petitioner is now before the Treasury for pre-audit, which was one of the steps as part of the compliance with the order of this court in WPC 268 of 2022. Let it be on record. You file it.
Please after 2 weeks, Your Lordship.
2 weeks. This is the matter after 2 weeks.
For orders, item number 6.
New implement. Yeah. Tell me. Creation of 9 supernumerary posts. It's under process. Any time frame was fixed? Any time frame was given to comply? So you take an extension if necessary anyway. So please.
Service upon respondent number 3 is still awaited, Your Lordship.
Okay. Eight petitioners, right? Only 2 respondents, DGP and you are appearing for Home Commissioner?
My Lord, I'm appearing for respondent number 1.
One, Home Commissioner.
And it is informed that the new incumbent has taken the charge, my Lord.
Okay.
So in the last occasion, petitioner deprayed for implement of
This is
the new
a problem for the petitioners.
Yes, my Lord.
Go on impleading, people,
Yes.
but it's personal to that. That only incumbent can
Yes.
do something about it. So maybe we can find some solution to this issue because they have no control over.
Yes.
Any petitioner has no control over administrative reshuffle. Once the matter gets anyway. Your good name, please. Appearing on behalf of the petitioner. Out of the 2 impleaded respondents, the service upon respondent number 2 within bracket DGP Nagaland is stated to be pending. Oh, sorry.
Respondent number 3.
Learned Counsel enters appearance on behalf of respondent number 2, DGP Nagaland. The learned government
I'm appearing for respondent number 1. Yes.
appearing for respondent number 1, Sri R. Vyasan, submits that in the meantime, a new incumbent has taken over the post of Home Commissioner and is required to be implemented. So your representation is there now. So you kindly implead. The petitioner will take steps for implement of the incumbent, the present Home Commissioner, Government of Nagaland, namely, you kindly give a.
Yes.
The learned government advocate may furnish the details of the official to the petitioner side. You take it and then you can implead quickly. Implead, you file an IA for impleading. Okay? Okay?
For orders, item number 7.
Please, my Lord. We have completed steps upon the respondent number 2, Lordship.
Just a minute.
I'm informed that it gets my learned friend. This is a POXO matter, Lordship.
It has been served.
Yes,
You are appearing
yes.
privately engaged counsel,
Yes.
not amicus. So you are the public prosecutor.
Lordship, on the last occasion, this honorable court has directed to produce the scanned copy, Lordship.
It has come. It has come, I think.
Lordship.
This is scan copy, no? GR 115 of 23. So can we take up the hearing? This is for orders, but
Yes, Lordship. In
should
fact,
I-
Lordship, the accused has been in prison for more than 2 years now. If Lordship, if the audio can be muted since this is a box.
Should we take up now, hearing? Should we take up today?
Yes, Your Lordship. I have no objection.
He'll meet.
Lordship, and if I may be permitted to refer to the second copy, Lordship. There is another petition filed by the same petitioner, Lordship, for this honorable
Unlisted
court.
one. Unlisted one.
No, Lordship. We actually, while filing a case, we give another copy, a second copy.
Okay.
So if I may kindly be allowed to rely on that second copy, Lordship, while making my submissions, because inadvertently we have brought the file out relating to the other case.
No problem. You take.
I filed a criminal petition in the same case, Lordship.
Mr. Koja, this. Oh, this sorry. This is the files. This is the scan copy. This is the file. Which matter? This one. I think my cost list is also gone. Sorry. Oh, that's salary matter.
Yes, Your
right?
Lordship. So, Your Lordship, what happened is that as per the direction of this court, we were actually directed to inquire as to why salary has not been paid, Your Lordship. We have made a payment, but Your Lordship, with great difficulties, we have make a payment. How, Your Lordship? If you can kindly come to my annexure 1, page 7 will be, it's a type copy, so I'll refer to page 7.
Your affidavit?
Yeah, by affidavit, which I filed this morning, Your Lordship. Page 7.
No, this is a recasted petition. This one, not. Amended cost title. No, it will be here. Respond number 1.
Yes, Your Lordship, respond.
How many respondents are, this is 5?
4.
Okay. 4 respondents.
Yes, Your Lordship.
Petitioners are 367, right? And there are 5.
Yes, Your Lordship.
And there are 5 respondents. 5 respondents.
And you implement, yeah, you implement. 4, yes, 1 to 5, Your Lordship.
Respond number 5.
Yes.
Mission director.
Yes, Your Lordship. But more or less, the
Samagra Shiksha.
affidavit of the respond number 1 will cover.
Anyway, so where should I go? Page?
Page 7, Your Lordship. My senior counsel is going to take time, however, Your Lordship, for reply. However, Your Lordship, I just want to state the current affairs as to why we are finding a difficulty and as to why there was a delay of making payment, Your Lordship. Your Lordship, as this office memorandum, Your Lordship.
It has been paid now.
No, we have paid, Your Lordship. But
paid.
how we have paid, Your Lordship, I want to apprise this court. How we have paid, Your Lordship. Office memorandum, Your Lordship, dated 12 November 2024, Your Lordship. Your Lordship, here, previous, Your Lordship, what happened is that the central sponsor scheme, Your Lordship, what happened is that, Your Lordship, usually the state will give the salary to the teachers, and after that, we get reimbursed from the central, Your Lordship. That was the process, Your Lordship. However, by this office memorandum, with the introduction of SNS PARSH, Your Lordship, SNS PARSH, it stands for Single Nodal Agency System for Payment and Reporting Across Sector Holistically, Your Lordship. So the central has introduced this SNS PARSH, Your Lordship, and this was introduced to implement that like just-in-time payment only. That means there should be no advance payment and there should be no reimbursement. It will be just one time only, Your Lordship.
At the time, at the end of the month.
Yes,
at
at one time only the center will give, that's it. Previously what we used to do is that the state used to give. Yes. Then only we get reimbursed from the center.
Now the fund will come?
Directly, Your
and
Lordship.
to the,
directly to the account of the...
From the center?
It's from the center, and this has been made effective from 1/4/2025, Your Lordship. Para to, Your Lordship, close to. It was made effective from 1/4/2024. And because of this, Your Lordship, we could not able to make payment because of this introduction, Your Lordship. That's why on the next page, that is page 8, we had a meeting with the Chief Secretary also. The reminder was sent that like difficulties are being faced, Your Lordship. If we can see the relevant para on the last page. However, it is learned that it will not be possible to release salary in advance of the release by GOI under SNS PARSH effective from 1/4/2025. This will adversely affect the teachers. It is therefore requested that the GOI may kindly guide the state to resolve the issue for timely release of salary to the teachers. So, Your Lordship, the government actually wrote to the central regarding the difficulties that the teachers will be facing. with the introduction of SNA and SPART. We wrote it again, we give a reminder on the page 9 again, we did a reminder, but however with no reply. The government make an effort, and this time also we have make an effort and we have make an adjustment and we have given an advance payment to the petitioners, Your Lordship. So 4 months we have already given out the salary.
For
But-
March.
Yeah, but we have, yeah, but that is from the pocket of the state, from the exchequer of the state. Because now with the introduction, it is direct to the account.
Right. For
So-
those months, you have to seek reimbursement. Right?
Yes, all those steps. But now with this introduction, now we have to
March, April, May, June.
March, April, May, June. It was made effective from
July, August,
April.
July
Yeah.
onwards pending.
Yes. So now, but they were not paid from April, May, June, July. So, but somehow we made an arrangement and we have made that payment to them. Because last time the petitioner was making complaint that like, no, we have not been made payment for the last 4 months. That's why somehow we have made an arrangement and we have made the payment, Your Lordship. Now, but the difficulty we are facing is that, Your Lordship, there is no more advance payment. And now there is no more question of reimbursement from the central also. It is bid directly to the account of the petitioner. So that's why we had a meeting. The government had the meeting with the representative of the teachers, and on that we make an agreement that they should undertake an agreement stating that as soon as the SPART credited the amount to their account, the amount which we have been given to them should be returned back to us. Because it will be a double payment, there will be a double payment. Because now what happened is that the SPART is such a policy that the amount will be credited directly to the account of the petitioner. So we have actually discussed with the president as well as the vice president of the Teachers Association, and we apprised them that you have to take an undertaking because now the amount will be credited directly to your account, and now we have made an advance payment to you. So if the amount goes directly to your account, then the amount which we have given to you should be returned back. So that was the condition and that was the reason we took an undertaking. And so basing on that, we have given 4 months salary to them. Now what happened is that in the meantime, Your Lordship.
Undertaking has been taken already.
Yes, we have taken. They have not given. They denied to give. And only on 8, they signed the
8th of this
undertaking.
month.
Yes, that's why we have actually released money to them for the period of 4 months, Your Lordship. That is April, May, June, July. Now, Your Lordship, even in the future, so I think we will be having a practical difficulties because it will be credited directly to them. There is no provision for advance payment, so we are having that practical difficulty. I just want to let this Lordship know about the practical difficulties we are having. And meantime, Your Lordship, now what happened is that against this contempt now, Your Lordship, I have preferred and review again.
No, against the writ petition.
Yes, against the contempt, against the division bench, Your Lordship. We have gone to the SLP and SLP will withdraw. And now we have actually filed review before the Supreme Court.
The
Your Lordship.
writ appeal.
Review before, I guess, against the SLP.
Review here.
Yes, no, in the Supreme Court, Your Lordship.
In the review also.
Yes, it has been registered, Your Lordship, my annexure 13, page 6.
Review before Supreme Court against against the SLP.
Yes, Your Lordship.
Which was dismissed.
Yes, Your Lordship. So, Your Lordship, we are just stating that give us some time, at least so that it will be subjected to the outcome, Your Lordship, of this review. Review is just been registered, it has not come out of motion, and that's why the petition is saying that there should be a stay. But now it's not being listed. That's why, Your Lordship, we cannot able to say we cannot able to confirm that there is a stay because it's just to be listed. We have registered this review. Therefore, Your Lordship, my humble prayer is that let this contempt be subjected to the outcome of the review. That is my humble prayer.
Lordship, what the learned government advocate is submitting is outside the purview of this contempt petition. Now, my Lord, in the previous writ petitions, my Lord will kindly appreciate that the petition, now they are submitting before this Honorable Court that we are centrally sponsored scheme. That is already discussed in the previous writ petition. What has happened is, in the previous writ petitions, Lordship, we were appointed in a state post creation post.
In a state,
in a state creation post, not from the centrally sponsored scheme. We discovered that and we approached this honorable court. What has happened is, in 2017, Lordship, under the central scheme, our salary was reduced to 25,000 from 31,000. There was open advertisement, Lordship. We were recruited legally. Then it was advertised under the RMSA scheme. We were recruited legally, and thereafter, they reduced our salary. We were appointed on a fixed salary of 31,350. That was a fixed salary.
but it was reduced.
Yes, at the time of appointment. So what happened is the central government administrative structure at various levels created SSA, RMSA into new Samagra Shiksha. Our previous SSA, RMSA, all those were structured into new Samagra Shiksha in 2017, Lordship. Thereafter, our salary was reduced to 25,000. So we went for agitation, the petitioners, we went for agitation for reducing our salary from the 31,350 to 25,000. While we were on agitation, Lordship, we found out, it came to light, we were appointed in a state post creation post, state cadre post. That is the crux of the case here, Lordship. We were appointed in a state cadre post. So we approached this honorable court to provide us our post creation state cadre post, because we were recruited legally through open advertisement. There is no backdoor or there is no other hanky-panky. Now, Lordship, what has happened is and we did not ask for upgradation of our scale pay to 31,350. We filed a writ petition to give us our state creation, post-creation salary in the writ petition. Now what has happened is the single learned judge enhanced our salary to the previous salary, 31,350.
Single judge.
The single judge. But the single judge denied us our post-creation payment.
Prayer.
Our prayer. So we went for appeal. In the appeal before the division bench, the division basing upon equal pay for equal work, the division bench directed, Lordship, the state government will kindly come to page 81.
Yes, I'm on 81 only.
Yes, 81.
Para 19, madam?
Para 19 and 20. That is very clear.
Let us see and read.
Yes. So the division bench directed the state respondents to give us our post-creation payment. That is rupees 9,300, 31,800 with grade pay of rupees 4,200. Accordingly, it is directed to the state respondent to grant such scale pay to the petitioner forthwith. So now what has happened is, forthwith, my lord, in your wisdom, knows that it will operate on 16/3/2022, the day when the judgment order was passed. So from 22/3/2022, we are yet to receive our payment salary, regular salary, Lordship. Then they went to Supreme Court appealing against this judgment order. Then the Supreme Court dismissed the SLP. That, Lordship, have I...
SLP is dismissed, and then now they filed a review petition.
Review petition. But Lordship, in your wisdom, knows that review cannot reverse the order. There is no reversal. And for whatever reason they are filing, that I still have not come across it yet. But in review, whatever they have filed, Lordship, the fact that the judgment cannot be the judgment cannot be reversed back. That is the settled preposition, Lordship. The Supreme Court order, Lordship.
I've seen it. It's
Lordship,
here.
Lordship.
This,
In my
someone, they have supplied this one.
sorry, Lordship.
Short order.
It
Yes,
was,
sure,
it
sure.
was dismissed and withdrawal.
So here, we are not. They are submitting before this honorable court that they are paying 31,000. We are by now. We did not accept this 31,350 when this this form was issued, Lordship.
But this issue of pay scale, the direction was to grant the pay scale.
Pay
In
scale.
the band of 3,300 and 34,000.
Yes, yes,
This
Lordship.
band, right?
Yes.
So, but is this, how is this related to this scheme of
Yes,
that, you know, that
definitely.
direct payment into the accounts of the.
It is not related. That's why,
No, no.
Lordship.
Because-
Lordship, the fact that it will come later on, but the fact that we were appointed in a, see, Lordship, in a service jurisprudence, the advertisement as well as the post where we were appointed. The post where we were appointed is a state post creation post. So we have to, they have taken over similarly situated persons as a state cadre when this case was pending in the single bench. Other similarly situated persons have been taken over because they were also appointed in a state post creation post. Other similarly situated who were appointed in 2010-2013, Lordship. We are 2016 batch. It was appointed in a batch. So other similarly situated persons have been already taken over by the state. So here we have been appointed in a state post creation post, and even if I don't place before this honorable court, automatically, Lordship, the post creation post that we are appointed, we are also state cadre. So we are not on the 31,350. Now we are before this honorable court in contempt. We are not concerned about that previous fixed salary. We are concerned about granting us our salary, post-creation pay band with effect from the date when the judgment order was passed, because the judgment order says forthwith. So we are to be paid our salary with effect from 16/3/2022. So we are on that. This contempt is on that, not on payment of 31,350. So where is it connected?
Your Lordship,
I'll just come to you.
Your Lordship.
I'll just come to you. This is the operative paragraph, para 19 of the writ appeal.
Yes.
Right. And now you file this affidavit. Just let me read this affidavit.
Shall I read out, Lordship?
No, I'll read it myself. Salary of.
It's not a question of giving us the 31,350. That is not.
Initially, I thought that it was the writ petition, the writ proceeding was with a grievance of not getting the salary. But
No.
They've said that now the salary has been cleared till
No.
July. But the operative direction in 19 is about scale of pay.
Yes, exactly. I am on that. And this contempt petition is for granting us scale of pay. And now they are talking about whatever this is. They are talking about.
This may be a good method to pay disburse salary under centrally supported schemes. But the linkage with this, I have to hear you, please.
Yes.
So, because it's at the stage of admission, but anyway, it's not be possible to dispose today. Maybe your brief submission.
Your Lordship, may kindly see as to why my affidavit has been filed, Your Lordship. This affidavit was filed on the direction of this honorable court as to why the salary of 4 months was not being granted. We are not into the order now, Your Lordship. We are just into the order passed by the honorable court on the last date, Your Lordship. On the 18th, Your Lord, there was a direction, specific direction that why we have not given a salary, 5 months salary to the petitioner. Because the petitioner has made a complaint before this Honorable Court on the last occasion, stating that we have not been paid 5 months salary. That's why there was a direction, specific direction from this Honorable Court to obtain instruction why we have not been given salary. That's why, Your Lordship, we have made a submission that because of these reasons, we are unable to pay, and that's why but till then we have made a payment as per the direction of this Honorable Court. We have made a payment for 4 months. Your Lordship, that is as per the order of this Honorable direction of this Honorable Court. Now, coming to the this petition, Your Lordship, we have said that we have filed a review. Review is filed on what ground, Your Lordship? Where there is an error in the facts and law, Your Lordship. That's why we have filed a review, Your Lordship, against the order, Your Lordship. That's why, Your Lordship, we are just seeking some time.
Don't you think it would be, no, it's okay.
It's not about
Don't you think
compliance.
it would have been a better idea to file the review here? Because the SLP has been dismissed, you know.
No, it's being filed in the Supreme Court, Your
Yeah, it has
Lordship.
been dismissed in limine, actually. SLP. No?
Yes, SLP was withdrawn, Your Lordship. We dismissed on withdrawal, Your Lordship, if I'm not mistaken, Your Lordship.
Lordship,
So, Your Lordship, my humble
when
prayer
my
is just...
when my contempt pending before this Honorable Court is on, giving me the payment, my post-creation payment. Where is the question of discussing about that
So, I
350?
think, don't you think that it will be better to have an affidavit from their side on this specific prayer, that why the scale of pay, this will be recorded, of course, that there was a direction to submit this status about payment, non-payment of salary. This will be recorded.
As far as the
this
payment...
SLP, ma'am, this SLP is that we are not inclined to interfere with the interim judgment and order. Hence, the special leave petition is dismissed. Withdrawal, it's not written here. I don't know. It was on withdrawal.
It was... Yeah, Your Lordship.
Not written here.
Okay.
Anyway, so maybe on because because this order gives me an impression that it was dismissed in limine.
Yeah. Your Lordship, however, Your Lordship, one thing is that we're just filing. That is our prayer, Your Lordship.
You have a right to file.
It's up to the court whether to accept or not, but Your Lordship, my humble prayer is that since review has already been filed, maybe the petitioner might be of the view that it's a wrong thing, but still we have filed.
Would the respondents represented by you like to file an affidavit on this aspect, the pay scale, what is the difficulty the government is facing, whatever, on giving the pay scale, because this is on a slightly different issue, which was necessary because of the direction of the court. I understand.
Yes, as far as like this is concerned, Your Lord, you just said that we have filed
In that
a review.
review, in that affidavit also, you can mention about this thing that, you know, review has been filed, but whatever, because as a petitioner's counsel, she wants to know.
I think they have written.
Yes, we can.
They have already filed.
Ma'am, the petitioner counsel is anxious to know as to why the pay scale is not being
Yes, that is
and
so.
what
This
is the difficulty.
That's why, Your Lordship,
This is the purpose of filing this contempt petition. Why should I divulge into that fixed payment?
Anyway, this was also a grievance which emerged during this proceeding, that they were not getting salary, since a person who's working should get salary. So therefore, it was directed. So they filed this. That's okay, no problem. So at this stage, I will record this submission of yours and also reflect this, and then you may.
I will also file my.
we can also.
But what I feel, ma'am, is that since the issue is the granting of the direction is the granting of the pay scale, so it will be good to let her. She represents, she represents the government, but she is not into that internal decision-making process. So you can take instructions.
Yes, Your Lordship,
And then
I can elaborately file my
affidavit about with regard to what has been directed in para 19 of the review.
Yes, Your Lordship, that too, Your Lordship.
For the moment,
we have just stated that it's humble prayer that like review has been gone, so at least sometime review will be listed any moment. So
this filing of this affidavit, and thereafter ma'am can file a reply if she wants. But now I think, in my humble opinion, your reply now would be, your affidavit now would be premature. Let them, let you hear what they have to say.
I don't know whether they are going to rely on this or they are going to file a new affidavit.
No. This does not touch that issue of para 19. So they have to file a new.
Yeah, para 19 to Your Lordship, we have the reason why we have saying that like more or less we have filed a review against.
No, first you take instructions.
Yes,
and
Your
then if you want, you can file an affidavit. That's what I will say. That's what I will say. The matter, should it be allowed to continue at the stage of admission only? Should we
Yes, Your
go
Lordship.
further?
Yes.
Should
yes,
we
yes.
admit it?
Yes, yes.
Should be
Your
admitted?
Lordship, let it go, Your Lordship. We'll
Hearing.
no, Your Lordship, in the admission only, Your Lordship, in the admission stage only.
Heard G. Momi, learned counsel appearing for the contempt petitioners. Also heard Ms. Evika, learned government advocate, appearing for respond number
For all the 5.
for all the 5 respondents. Full stop. Peruse the last order dated 18/8/2025. Full stop. It is reflected therein that based on a statement from the petitioner side that the petitioners were not getting salary from April to 2025. This court had directed the learned counsel for the respondents to take instructions, and pursuant thereof, the learned government advocate, upon instructions, has filed a affidavit on behalf of the respondent number 1. It is stated, what emerges from the said affidavit is that earlier you cut that, right? On the basis of the said affidavit, the learned government advocate submits that earlier there was a system of the government paying the salary to the.
Just a small clarification, my lord. Since the SLP was pending thereafter the division bench disposed of the allowed the writ petition, they filed SLP, and since it was pending, SLP was pending, we did not object and we were getting our salary, that fixed salary, because we have to wait for the outcome of the SLP. But after the dismissal of the SLP, they have to pay us our payment salary. That's why we did not accept. However, on protest, we have filed an application before only on protest we have accepted it.
What was the last word? Is that? No, need stand. Sit. Salary, but due to a change of the payment modalities brought about by the union government and making a transition to payment through a single nodal agency model, the salaries were to be directly credited to the accounts of the petitioners, the concerned employees, unlike in the past where the government used to first pay the salaries and then get reimbursed from the union government. In this context, the Learned Petitioner Council submits that as the respondents had filed an SLP before the Honorable Supreme Court, therefore the petitioners were ready to accept the fixed salary, which, however, did not come to be paid since March, as already stated above. The learned government advocate further submits, on the basis of our affidavit, that in the meantime, the state government, by arranging finances from its limited resources, has managed to pay the fixed salary to the petitioners from March to July.
Yes, sir.
March to July. Full stop. The
No,
petitioner.
Your Lordship, April, May, June, July.
April to July. Sorry, April to July. The Learned Petitioner Council submits that the said salary was accepted on protest
By submitting a representation.
by submitting a representation and agreeing to refund the same.
Yes, yes.
Refund the same when the salary comes into their accounts.
Lordship, that is not, we submitted that representation against this salary, because if you go by the Supreme Court
Yes.
dismissal
Let us
and
not write
this,
that. Last line you need not write that.
Your Lordship, that is about the undertaking they have taken, Your Lordship.
Undertaking has been given,
Yeah,
right? So for
undertaking they have
reimbursement.
given, yes.
And undertaking was given, but I'll fine tune it. I'll just write it now. Undertaking was given on behalf of the petitioners that in the event of the salary being credited to their account directly in the future, they would return back the said amount. Next paragraph. The Learned Petitioner Council submits that as the respondents had filed an SLP in the Honorable Apex Court, therefore, they were willing to receive the fixed salary. However, the said SLP has in the meantime been dismissed by order dated 20th May 2025, and therefore the petitioners are aggrieved by non-compliance with the direction given in
16/3/2022.
direction given in para 19 of the judgment dated 16/3/2022, passed in WA number 9 of 2020, within bracket arising out of WPC 174 of 2018. Full stop.
WPC is 2020.
Arising out of WPC 174. Don't write it. WA card number is correct, right? 9 of 20.
W9/2020.
That's all. Don't write the WPC number. The Learned Government Advocate, however, submits that the respondents have preferred a review against the dismissal of SLP, and therefore some time may be given for the same. The Petitioner Council submits that
Pending of review does not bar the
submits that the petitioners are aggrieved by the continued non-compliance with the direction in para 19 of the judgment in the writ appeal for granting them pay scale. In the aforesaid facts and circumstances, the Learned Government Advocate shall take instructions from the concerned respondents as to why, as to the status regarding compliance with the direction given in the aforesaid para 19, and the respondents will be at liberty to put their contentions in an affidavit, if any. File an affidavit, if any, in this regard. Would be at liberty to file an affidavit, if any, in this regard. So let it stop here. For the moment.
More or less, my prayer is that because of the
Lordship,
review, we are unable to process with the team. However, yes.
in that
Now I get the complete picture.
Yes, Your Lordship.
So should we? Yes,
in that case, let them file their affidavit within a specific time. Then in the meantime, I can also reply, and when the matter is listed again.
Your Lordship,
list after.
my humble prayer is that like 4 weeks be granted. Within that, maybe the review can also be done, Your Lordship. So 4 weeks.
This
so
review,
that within the time.
this review seems to be pending again for Thy Kingdom Come, because for twice they have been pleading
And the
before this honorable court twice.
Cannot bargain between you. But can you settle for 3 weeks?
Your Lordship, if 4 weeks, so that Your Lordship, at least we will know the outcome of the review also
The
within
Learned
that time.
Government Advocate prays for 4 weeks time, further submitting that in the meantime, the outcome of the review petition might also be known.
Yes, Your Lordship. So that's my humble prayer.
Matters take time to come up, so many cases. That is
More
a
or less, Your Lordship.
logistical problem anyway. She has been accommodating, madam. List
Yes,
after
Your
4 weeks. You want me to fix a date or after 4 weeks like that?
Fix a date, Lordship.
List after 4 weeks on. Today is 4, right? 11, 12, Then we enter the holidays, but here the holidays are not there. Can you help me with the October dates, please?
On October 9th, Lordship.
9, 10. This order will help for future reference.
Yes,
Lordship, Lordship.
Because again, you have to need not submit. You can just draw, if there's another judge, you can draw attention to this.
yes, Your Lordship, yes.
That is why it is important to record correctly.
Very true, very true. Much obliged for your graciousness.
Obliged, Lordship.
Bail matter, we can-
For hearing, item numbers 9 and 10.
May I please, my lord?
Any supplementary matter for admission? Supplementary matter is not there, apart from the judgments. Huh? Judgment. Ready? Defective. Come up on Monday or something. These are connected.
My lord, out of the same affair, my lord.
Same.
My lord, the applicants are presently at interim bail.
Yeah, I just noticed.
Now, the IO wants to clarify something, so as someone was issued, and to one particularly to Mr. Mukesh Chaudhary. Now, either for the reason known to them, they could not appear. So, in the interest of justice, if they may be directed to appear before the IO and clarify the matter, and after that, if the matter is listed again, so that instead of going to the merit of the case.
In that regard, my lord, may I submit, my lord?
Just a minute. No?
My lord.
Can I have a look at the FIR?
Yes, my lord. My lord, before coming to
You
the
want to say
FIR.
something? Yes.
Yes, my lord. May I, my lord? My lord, we have already appeared and we have already recorded our statement, my lord. And the situations, under what circumstances we have recorded our statement, my lord. So, my lord, before start with the FIR, may I submit, my lord?
Yeah.
My lord, on 7/5/2025, this honorable court, my lord, has granted both the petitioner interim protection, my lord.
Both the cases.
Both the cases, my lord. Here, my lord, the accused number 1, who is named in the FIR, Wasif Rahman, he was already arrested and he was already enlarged on bail, my lord.
Yes.
Now, after granting this pre-arrest bail, my lord, we are directed to appear before the investigating officer and to appear before him and record our statement. But, my lord, we have repeatedly received threat calls from the informant. And therefore, my lord, both the present petitioner, they are the residents of Gauhati, my lord. Thereafter, on 27/5/2025, we have appeared before this honorable court and filed an additional affidavit stating all the facts. And thereafter, this honorable court has directed to appear before the Commissioner of Police, Dimapur, my lord. And accordingly, what happened, my lord? When we appeared before the Commissioner of Police, as per the direction of this honorable court, we have recorded our statement, and we have also furnished the bank statement, whatever we have, what relation we have with the Wasif Rahman, because he was the main accused. That it is surprisingly, my lord, on the same day, my lord, the informant was also present along with the IO, and my lord, on that day also they were threatened us. In fact, my lord, thereafter, till today, my lord, they are threatening us that if we appear before the investigating officer, Dimapur, my lord, then we cannot return, my lord. That was threatened. We have filed 4 affidavits in this regard, my lord. Now, my lord, kindly come.
No, let me read the Azahar ones.
My lord.
Because I need to know the backdrop of this.
My lord.
What is the allegation?
Yes,
the first thing.
Yes, my lord. My lord, the FIR is page number 15.
No problem, I'll read it myself.
My lord, in item number 10, kindly take, my lord.
No, it is para 14. Sorry, page 14.
My lord, in item number 10, it is.
Okay. You want, that
Yes,
should
ma'am.
be
Yes, ma'am.
item number 10. Mukesh Chaudhary.
Okay. Item number 10, page 15, my lord.
Page 50.
Yes, my lord. Copy of FIR, my lord. My lord, these are the additional affidavits, my lord, I have marked. The main application is in.
Okay. FIR before the commissioner is Nitesh Rastogi is the informant, right?
My lord.
Yeah. Okay.
Here, my lord, in the FIR, there are two named accused, my lord, Mukesh Chaudhary and Wasif Rahman. Here, the allegation in the FIR that the informant has deposited, my lord, an amount of rupees 55 lakhs and an amount of rupees 15 lakhs in favor of my lord Wasif Rahman, my lord. So, my lord, what happened, my lord? The Unique Motors, the Madan Sharma was the proprietor of the Unique Motors, and this FIR was lost by one of the manager of the Unique Motors. The allegation is that, my lord, that the Madan Sharma, who is the proprietor of this Unique Motors, he has also a shop in Adgao area, Gauhati, my lord. Then in item number 9, that is the petitioner Mukut Nair, he is the employer of said Madan Sharma. He is not named in the FIR, my lord. So thereafter, what happened, my lord? That Mukut Sharma and the present informant, they went to Gauhati and they meet, my lord, that is Mukesh Chaudhary, present petitioner. And present petitioner introduced Wasif Rahman, who was an employee of Mahindra Motors. So there is a deal between the informant and the Wasif Rahman that the Wasif Rahman will supply some spare parts of Mahindra manufacturing company to the informant at the Dimapur. So in that extent, my lord, the informant has stated that the Wasif Rahman stated that he needs some security deposits from the informant, and accordingly, the informant has agreed. But informant says that no, after depositing the security deposit, you have to deposit 2 numbers of check in favor of the informant, my lord. Now, my lord, kindly come to page number 37 and 39 of my first additional affidavit, my lord. I have flag mark, my lord, in side, my lord. Page number 37, my lord. First affidavit, my lord. It is filed on my lord 27/5/2025.
How many additional affidavits are there?
There are total 4 additional affidavits.
4
my lord.
additional affidavits.
Yes, my lord. But I have checked it marked, my lord, by date, my lord, right side, my lord.
The affidavit dated
27/5/2025.
just a minute.
In the right side, my lord, the yellow color or green color, my lord.
Third affidavit.
Second affidavit. In all affidavits, I have marked, my lord.
Fourth affidavit. Right.
First affidavit, my lord.
Yeah. Second affidavit I've got. Page number?
My lord, first affidavit, my lord, page number 37.
First affidavit.
Yes, my lord.
Is
37, my lord.
yes.
My lord, this is the security deposit that's stated by the informant in the FIR. That is dated, my lord, 28/12/2022. Here, my lord, will find deposited amount 55 lakhs. Now, in the below, my lord, received by Wasif Rahman. That is the accused number 2. Then, my lord, the second is page number 39. That is an amount of rupees 15 lakhs and received by Wasif Rahman. Meaning thereby that the whole amount has been received by Wasif Rahman, and he was supposed to deliver some parts of Mahindra to the informant, my lord. And to that extent, my lord, some parts was already delivered to the informant, my lord. Thereafter, what happened, my lord? He has failed to deliver some parts to the informant, and informant lost this FIR. And before losing this FIR, the security checks which were deposited in favor of the informant, because the present petitioner, Mukesh Chaudhary, he was a friend of Wasif Rahman, and he stood as a guarantor in this whole transaction. And he has issued 2 checks, my lord. My lord, in the second part of the allegation is that 2 checks were bounced, and thereby I have committed an offence under section 138 Negotiable Instrument Act. Now the section has been registered under 406, 420 and 138 of the NI Act.
138 is different.
My lord, my submission is that the dominion over the property under section 406, it is from the FIR and from the document which I have shown before the lordship. It is very much clear that the amount has been received by Wasif Rahman, not by the present petitioner.
Criminal breach of trust you leave aside for the moment.
Mine.
120. And so at this stage, case diary has been called, I believe.
Yes.
It has been received also. The case diary, the scan copy of the original case diary. Scan copy of the case diary. But at this stage, you appear, will extend the interim.
My lord, may I submit? My lord, we have already appeared. To that extent, my lord, I have filed an additional affidavit. Kindly go through once, my lord.
We are not denying that.
My statements were there, my lord.
Now, the impression he gives is he doesn't want to appear again, but just for clarification, he's summoned again, that's all. But he's
He
not,
appeared once, he is
Yes.
summoned again.
yes,
So,
as you can say,
you can appear, or you can even appear through online mode also. We have given in other cases also.
yes.
Nowadays, this is not a problem. Online mode also you
Madam,
can appear.
I am ready
Yeah,
for-
and if the petitioner is also a citizen of the country, and so if he has apprehensions about any apprehensions about security in cooperating with the process of law, that direction we can also give.
My lord, my lord.
So at this stage, thereafter, once your statement is recorded, once you appear, if the investigation progresses, then we can think of making this
My
absolute.
lord, already what I am submitting, my lord.
Let the check bouncing case proceed, and this
Yes, my lord.
investigation will progress.
I have also taken some new grounds in my additional affidavit, my lord, because I was not the earlier engaged counsel. My lord, what I am submitting, my lord, in my third affidavit, my lord, which was filed on 12/6/2025, lordship, kindly go through once the para number 3 and 4, my lord.
Okay.
My lord, in this case, my lord, I have only named because the check which I deposited as a security, I stood as a guarantor, and that checks were bounced, my lord. Only to that fact, my lord.
Yeah, please continue.
My lord, only for that fact, my lord, I was named in this FIR. Otherwise, my lord, I have stated in my 4 affidavits, my lord, my role as I have stood as a security in the said transaction, my lord. And in item number 9, my lord, the person, he's an employee of this Madan Sharma, this proprietor, informant. He has no role, my lord.
Employee of the informant.
Informant, my lord. That is a proprietorship firm.
What is the allegation against him?
Allegation is nothing, my lord. In the FIR, there is no allegation, only because of
He is
that
apprehending us.
yes, my 35(3) notice was served to him, and he was not appeared. Only that fact, my lord.
Please.
Lordship, he introduced the present accused.
With the
Yes, that is his
so he's
yes, yes, in the finance, and he accepts some money.
proprietor is aggrieved by that, so he
Yes.
suspecting him. So anyway, let me have a look at it. Otherwise, I think at this stage, it is since they are seeking his presence, extend it and let them appear.
Yes, yes, I do.
My lord, may I pray, my lord, we will appear from video conferencing, my lord.
No, that is one of the options. That
My
is
lord,
one of the options.
Because, my lord, already we have appeared, my lord. Investigation is there.
Distance is there.
See,
That is one of the options.
It is like cooperation with the IOS helping himself. If they have enough
True.
materials, then
You make your case out.
This
Okay,
is
that
the-
option will be there. That
yes,
option will be
that
there.
is the status report.
No issues.
This is the CD.
Let me read this. Give me 2 minutes. Okay.
My lord, otherwise the investigation at this advanced stage, my
Because
lord, and based on
the
documentary
investigation has found a lot of incriminating materials as for this. You know, that they conspired to cheat that person. And if the allegations in the FIR is true, that somebody issuing a check of say 40 lakhs and 35 lakhs and it bounces, so it reflects poorly. Anyway, at this stage I'm not considering the bail
what has
since he has appeared.
my lord.
Yes.
So let them, you know,
Yes, yes.
continue the cooperation. The Mr. Hallo,
My lord.
learned counsel for the petitioner, assisted by his name also.
SMBC.
Stop. It appears that 4 additional affidavits have been filed by the petitioner side in this matter. Peruse the relevant portions of the same. The petitioner was granted interim protection, same order, no? Same similar order. Almost same order.
Same order, my lord.
Was granted interim bail by this court on
7/5/2020.
7/5/2025
25.
with a direction to cooperate with the investigation. Pursuant thereof, the petitioner has appeared before the IO and his statement is stated to have been recorded. However, due to continuing investigation, he was again noticed and directed to appear, but he has not been able to do so due to some threats. The learned public prosecutor fairly submits that on one occasion the petitioner has appeared, both the petitioners have appeared,
My lord.
and their statements recorded. Scanned CD has been received. In the aforesaid circumstances, the interim protection granted by the order dated 7/5/2025 stands extended till the next date of listing. In the meantime, the petitioner shall continue rendering full cooperation to the investigation, and for this purpose, they shall appear before the IO again. yeah, when requested, IO again, full stop, if and when requested,
Lordship,
as and when required.
no, actually he's required now, as of the submitted. as
Appear
one-
before the IO,
as if-
as requested, as directed by the IO.
Yes, if a specific date is given, Lordship.
Okay. Appear before the IO again, as sought for by the investigating authority, full stop. However, considering the apprehensions expressed by the petitioner side, liberty is also given for such examination through online mode. And if the petitioner appears physically before the IO at Dimapur, the investigating authorities shall do the needful for his safety and security as well. Full stop. This you can seek an updated case diary, right?
Oh, yes.
This will remain. This is a scan copy.
Yes, yes.
The scan copy of the case diary be retained with the case record, be retained by the public prosecutor, and scan copy of the updated investigation may be procured by the next date.
Lordship.
That will be fine.
Yes, yes, Lordship.
This is the matter after
It's convenient, Lordship.
3 weeks, 4 weeks, 3 weeks.
Lordship. Lordship, but if a specific date is given for his appearance, the accused appearance.
I can give, should I?
My lord,
Specific date?
within a period of 10 days, my lord,
No, no, no.
through VC, my lord.
Any-
We'll
No,
contact,
that is one of the options.
Yes.
my lord, we will contact the investigating
No, no,
officer.
no. Take one
That's-
date and let us have a. So that we
Because,
have a definite date.
because IO may need one more date, more than one date also, suppose.
Yes.
So, the petitioner shall make such appearance before the IO within bracket physically or online mode, bracket close, within a period of 2 weeks.
My lord.
2 weeks.
Lordship, if a specific date is taken, that'll be better, I think, because we come up with some other reasons, then it's not convenient. So, for the convenience of both the IO as well as the accused,
My lord, what happens if the date is fixed, my lord? Sometimes in Jurabad area, we
No,
cannot come.
what I'm saying, Mr. Prosecutor, is
Yes,
that the IO may need him for more than 1 day, right?
yes.
So let us give flexibility to the IO also.
But if a date is fixed, and if he needs more date, they can refix it again. Because
The learned PP submits that fixing at least one date for such appearance would be helpful for the investigation. Accordingly, the petitioner shall record his first appearance before the IO on. Yes, you can suggest as per your convenience. You can suggest for
My lord, on 16, my lord.
on 16/9/2025
at 1 p.m. Lordship, at 1 p.m.
at 1 p.m.
Yes. Lordship.
This is the matter after 3 weeks.
Lordship.
My lord, till then, my lord, then is.
No, it's there. It's there. Should I fix a date for the bail petition? After 3 weeks?
My lord, we'll take a date from the postmaster.
No, that list after 3 weeks it will not be. It will be decided by the bench. List after 3 weeks.
Lordship, shall I take back the?
Yes. That is your material. Please keep it. You'll need it also.
My lord, what happened, my lord? In this case, my lord, the council, even they are threatened it, my lord. I am personally, my lord, they are calling WhatsApp calls, my lord. So therefore, my lord, the online mode will be.
No, I have given the option.
My
Nowadays, this can be, but show your cooperation.
My lord,
That
my
also
lord.
helps. Be in a cooperating mode. These things can be addressed. Because police is now in Dimapur is a law enforcement authority, right? So they are entitled. They are obliged in law to give protection to anyone. from this state, Nagaland, or from another state.
Highly obliged.
For motion from the supplementary course list, item number 14.
One matter. Yes, tell me. Okay.
May I please proceed? The petitioner filed his bail application on medical ground. He was arrested on 25/6/2025 from Kusama Gate, and accordingly, Kusama police, a special case 17/25 under section 22C NDPS Act with section 35 of BNS case was registered against him. And my lord, prior to his arrest, he had numerous health complications, and he was suffering from bleeding while passing stool and chest pain.
He is presently lodged in Dimapur jail.
In Kohima district.
Kohima jail. District jail.
And because of his health complication, the special court NDPS had taken cognizance and directed the jail authorities to take him to Naga Hospital, which is district hospital. And he was taken to district hospital on 3 occasions, 10, 7, 13 August and 21 August. And on the first day, he was given medication. But since there is no improvement, on 21/8/2025, which I have annexed on page 20, the medical officer have advised him to go for hemorrhoidectomy, which is surgery of his hemorrhoids. But since his family member is not here, he is from Sanamai village, which is under Senapati district in Manipur. So because of that situation, the jail authority could not admit him to go for surgery. So, my lord, and I could not approach the special court NDPS Kohima as the session judge, special judge is undergoing training. So, since his health deteriorates day by day, I have approached this honorable court, my lord. My humble prayer is that I may be enlarged on bail to avail advice medical treatment at the earliest, my lord. This is my humble prayer, my lord.
But the problem is that it's a commercial quantity section, yes, right? And section 37 is applicable. So even interim bail on held grounds, though constitutional provisions are there, but interim bail on even held grounds would not be so easy to give.
Yes.
Of course, the easiest thing would be to direct proper treatment. But if he requires any kind of medical attention which is not available here, then it remains to be seen what can be done.
My lord,
I'd like your guidance, assistance.
Yes, my lord. Let the matter will come up on Friday.
No, Friday is a holiday.
Yeah, this Friday. Thursday then.
Next Thursday.
Yes, because meantime, let me produce the city.
That can be done, of course.
Yes.
No, that will be done. You
Yes.
call for the city. But you are seeking interim bail.
Yes, my lord.
He is seeking interim bail. So let us do one thing.
Then,
Let
my
us
lord, since the petitioner is already in the custody.
Let's do that.
Yes.
Apo, you can start. The present accused, Sonu Pao, was arrested in connection with Kusama PS case number 6 of 2025 under section 22C of the NDPS Act, read with section 35 of BNS, on 25/6/2025 and presently stated to be in judicial custody in District Jail, Kohima. Heard learned counsel for the accused, who drawing my attention to the annexed medical documents, contains and submits that the accused is seeking interim bail at this stage on health grounds, as he suffers from multiple health disorders, including hemorrhoids.
Yeah, internal hemorrhoids.
Including hemorrhage, for which he has been suggested to go for surgery. It is submitted that his family members stay in a interior place in the district of Senapati, Manipur. Heard learned public prosecutor to the state who seeks the case diary. What we'll do now is that in the foresaid facts and circumstances, call for we'll call the original case diary. Shall we call the original?
City scan, my lord.
A scan copy
Scan
of the
copy.
case diary till the up to date stage of till the latest stage of investigation. It's next. Also call for a medical report from the learned superintendent of district jail Kohima regarding the health/medical condition of the accused. Now, the next direction is that in the meantime, the learned jail authority of Kohima jail is directed to provide necessary treatment to the accused to improve and stabilize his condition. List on Thursday.
Yes, my lord.
List on, what is the date? Can you help me with the date? 11, 11/9? 11/9. Huh?
No, my lord.
10/9? you
Date
prefer?
9 is, I have some difficulty on date
No,
9.
10/9 is a division
11,
bench.
my lord, yes.
Division
11.
bench also. 11/9 for case diary and medical report.
Yes, my lord.
A copy of this order. You want a free copy?
Yes, my lord, yes.
May be furnished to the learned PP as well as sent to the learned superintendent district jail Kohima for the needful. Okay.
Much obliged.
In the meantime, please, let us do some homework. We look up, you can also look up that what is the, what is the latest legal position with regard to the interplay of Section 37 and Article 21. I have come across cases where even in advanced pregnancy, bail has not been given. I've also come across some cases, though I don't remember the details, where invoking 21 in health situation, bail has been given sometimes. District courts, special courts don't have that power, I think. They have to only go by 37. But High Court might have a little more flexibility. So we look for some case laws also. Try to look for some case laws
Okay.
on the point.
Much obliged.
Guide us. Okay?
Much obliged.
Pardon? DB. Sila. Sila là kia mà. Ah. DB very last moment no. Yeah. Silipuara.
Hello, ma'am. Hello, sir. Sir, is there any change in the schedule or something? The judgment was supposed to be delivered at 2 p.m. no?
Yes, but was a DP.
Okay. Okay.
Yari, low. For judgment, item numbers 11 to 13.
Criminal petition 33 of 24 is allowed. It is allowed. 33
Deeply obliged.
is allowed. Then 32 is also there. I think. This I found the facts a little different, 34. So the petition is dismissed. Investigation will continue. Right?
Deeply obliged. Your Lordship.
Huh? 32. And 32 also, the petition is allowed. 32.
Deeply obliged. Your Lordship.
So 34 is dismissed and 32 is allowed.
Deeply obliged.
32 and 33 are allowed. Okay.
Not supposed. Okay, sir, ma'am. See you.
Okay.
See you.